Thanks everyone for tuning in today and joining us. We've got a bit of a full court press here today with Andrew Shaw from down there, Andy from Windy Valley, and Fiona from Plainville, Auckland, here up north. What we're covering today is changes that the new government have made and changes they might make in the future, and some exciting new case law. So putting to one side various political persuasions, a change in government is always a pretty exciting time for employment lawyers, and so there are a few hot topics here that we'd like to cover. We'll start with what we've got now, the changes the government have made in their kind of first quarter plan. And there are some basics here. So let's start with 90-day trial periods. Andrew, is this something all employers should now insert in their agreements?
Look, the government has changed it so that where you have a number of employees, and previously was 19 or less, you can now insert a trial period provision in your employment agreements. I think it comes back to the culture of the organisation and perhaps the level of the role that you're looking to employ somebody into. Some organisations might decide that their recruitment policies are good enough and they don't need a trial period as a backup. I also think that where you've got a more senior person in the organisation, you wouldn't put a trial period in necessarily, because that person's obviously leaving another senior role to come to you, and again, your recruitment processes have to be good enough. So for me, I think look at your culture, look at the role that you're trying to employ for, and decide, is a trial period necessary?
Okay, that's interesting. And for accredited employers, I suppose there's a little fish hook there as well, right? You can't use them for immigration visas.
Yeah, that's right. So Immigration New Zealand has said you can't use a trial period when you have a work visa for an employee. So yeah, just make certain if a person is on a work visa that you don't put a trial period in there.
Okay. And they look fairly simple on paper, but I think you see employers get tripped up actually quite a lot. Andy, can you cover any kind of fish hooks people need to be aware of there?
Yeah, you did right, Joseph. I think we probably work on a trial period gone wrong maybe once a month in the Wellington team, and I think an explanation of why that is, it's probably that the Employment Relations Authority and Employment Court seem to really hate trial periods, and I think that they've endeavoured to read them down wherever they can, and it's quite nuanced and complex how they've done it, but the essence of it is that, and a lot of people don't know this, that the employment relationship can form quite early in the piece, and there's at section 6 of the Act, what it actually says is it extends to people who intend to. And what you have in the actual trial period provision is it says that it must be in writing, and the employee has to be a new employee. So of course the trap there, and it starts with a case out in itself in Upper Hutt Stokes Valley Pharmacy, or Stokes Valley, sorry, I've offended anybody that doesn't in Stokes Valley that doesn't want to be associated with the Hutt. And what happened there is that the individual concerned came in and they worked for a period, I think it was just in the morning, someone will correct me if I'm wrong, it was just in the morning, and then they signed the employment agreement. The employer sort of poked it under their nose and said, signed here. And the way that the Employment Relations Authority dealt with that is it used the combination of those two provisions, that it must be in writing to a new employee, and said, well, they worked for you for that morning, and then they signed, and accordingly a period in writing. So there was a period where they were an employee, but they used that to say, well, the trial period's invalidated, and that naturally extends to other things as well. And we've had a client call out just recently with this, and it extends to a situation where employers might offer either verbally or with a cover letter saying, hey, you've got the job, and the employee accepts, and of course at that point the employment relationship forms, and if subsequently you give them an agreement for a trial period, then they're not a new employee in the eyes of the Employment Relations Authority, and people get caught. So I think, there's a real will to read them done. I think that that's only going to continue. And there's one other interesting decision I think you alluded to, Joseph, and that's where the termination itself doesn't occur in accordance with the provision. And what happened in a recent case, it's Verma versus MG Empires, as it said that the employee, when they're terminated on the trial, they could be paid in lieu. And the employer didn't make good on that payment in lieu, and of course that invalidated the trial period, and they were left arguing that the dismissal should be justified for poor performance. And of course they hadn't done a performance improvement plan, or they hadn't taken any of the steps that you need to address performance. So they were really, they were snookered essentially. If you have a trial period and it falls over, you've got a real problem with justifying the dismissal. So the advice that we always give, there's two pieces of advice. The first is, if you're going to use a trial period, reach out to your employment lawyer and just say, hey, can you just check out our documents and our clause just before we do it? That is, of course, unless you already have a Lane Neave agreement, which would be perfect. And also, I say to people, when you offer an employment agreement, there's only really one safe way to do it, and that's to cover that says, we would like to offer you employment. If you want to accept our offer, you must sign and return the attached employment agreement, and you also draw their attention in the cover letter to the fact that there's a trial period. And belts and braces, say go get some legal advice as well, and that'll mean that you're pretty bulletproof for the trial period.
Yeah, really good point. And I've seen employers come undone. I think there's another case where terms of employment were agreed very informally, a text message, and then without going through that step of actually getting the letter and please sign, including the 90-day, and they came unstuck there as well. And with notice, that case you're talking about there, the awards were fairly substantial. It was 15K H&H and $20 in wages. And that could have been simply by paying notice correctly of 1 week. So it's worth getting that advice and getting it right.
Yeah, it definitely strikes me as a little bit disproportionate, but that's the world we live in. So the institutions really don't like trial periods, in my view, and it's a bit of activism almost against it, I think.
Another one that we all expected, and there was a bit of a race against time for unions trying to get these fair pay agreements across before National came in, they've obviously been thrown out now altogether. Fee, do you see that as a loss at all?
Before I talk about fair pay agreements, I just wanted to say, sorry, I think we've got some sound issues today. So what we're going to try and do, which is completely contrary to our normal style, is we're going to try and keep really still while we're talking and not flap our hands around to hopefully fix the audio issue. Now, Andrew's already smirking because he already teases me about the way I use my hands when I'm talking, but we're going to give that a go. And hopefully that does improve things somewhat. But Joe, in relation to fair pay agreements, I don't want to get all political on this, but I think it is a good thing that they have gone. I guess my starting point is I think the idea behind them was actually really positive. I think we can drive wages up in New Zealand. I think that is a good thing. But there were two main issues with fair pay agreements in my view. First was I think it was the wrong mechanism. And I know unions who I were talking to, they were quite gutted when the legislation came out about how convoluted and complicated the whole process was going to be. Secondly, I think it was a bit of bad luck timing wise. Unfortunately, we just can't really afford it in New Zealand at the moment. So I think that the starting point is I think it is a good thing that fair pay agreements have gone. I think we're being a little bit naive though if we think that this is going to limit union involvement moving forward. If anything, I think it will be a real motivation for them to actually start to bargain now more with employers, so initiate bargaining, and also to create more multi-employer collective agreements. I think we're going to see a real increase in that. But to answer your question, I think it's a good thing, but I think we watch the space.
Yeah. Do you see, because that requires cooperation between unions in some cases when they were looking at fair pay agreements, do you think that's something that will continue at all?
I think there was a mechanism for that in fair pay agreements. I think your day-to-day collective bargaining, your day-to-day meccas, I'm not sure if that's easy to achieve. But it's like anything, the more you separate resources, arguably the less power you have. And if there are any unions on this, which I highly doubt, but if there are, there might be something in it for them to get together more often and work together on these issues.
Even just sharing of information, possibly.
100%, without breaching the Privacy Act, but 100%.
Okay. Another one that's really interesting is Helen White's restricted trade bill that was received a bit of press, which was a piece of legislation that was designed for people on low to middle incomes and essentially preventing employers from putting in place restraints of trade for those employees. Andy, any thoughts on that? Do you think it's something that could be revisited, or is it out the window?
I think, Joseph, my view on that bill was there was some merit in it, and also I think potentially some overreach and additional restraints of trade. They break into two categories: don't compete and don't steal our client. And I think the don't compete's very valid in respect of low and middle income earners, and I think that would give quite a lot of certainty that they can move freely, and that's a good thing. But I think in respect of don't steal our clients or non-solicitation provisions, there are businesses out there, and I'm thinking of client service small businesses, that their lifeblood is really their clientele, and sometimes the people that work for them, sorry, I'm gesturing too much again, crashing the sound of my gesticulation. And I think for those small businesses, it would be really problematic. And I'm talking about things like hairdressers and nail salons and those kind of service industries. And I think I think the statistic is that the economy is made up with a really big number of these businesses, and they need to be supported to protect particular rights and clients. And I think it's fair enough if they're employing people on the front line that have these connections to their clients that wouldn't otherwise have those connections, that there is some protection for that. So on solicitation is balance. And in fact, a lot of my employment agreements, I say to my clients, look, you don't worry too much with the non-competition. It's very difficult to enforce. Let's just focus on what matters, and that's protecting the client base. So that was my issue with the bill, Joseph. And look, I mean, I think you may see it reemerge. Yeah, I think. I'm not sure what David Seymour's position is on it, and he seems to be torpedoing a lot of things at the moment. But there was some sense in it, but a little bit of overreach as well.
Yeah, it's interesting because I think in the debate, the parliamentary debates about it was very much focused on just that non-compete aspect, and so interesting that has that overreach in respect of non-solicitation as well. Another big area of change that's always really controversial is the Holidays Act. And so Brooke Van Velden recently gave a speech to the Auckland Business Chamber, and this was a fairly sweeping speech about changes to employment law. Holidays Act was at the forefront of this, and I see Christopher Luxon's second core plan as well. At least this week he has take decisions on reform of the Holidays Act in his list there as well. So isn't this something, Fee, that we've already gone through and we have recommendations on the table?
Yeah, so the Holidays Act issue has been a bit of an emotional roller coaster, to be honest. So when Labor came in first time round, They rightfully identified that the Holidays Act was a mess. So I'm sure I'm not offending anyone on this webinar when I say that is a bit of a mess. They put together a working group to try and amend the Holidays Act. I was hoping they were going to scrap it completely and start again, but they didn't do that. Their piece of work made 20 recommended changes to the Holidays Act. I guess two highlights was the first, there were going to be some formulaic changes to how holiday pay, etc., was to be calculated. And also there was talk of people being entitled to bereavement leave, to sick leave from their first day of employment. Jump ahead, Jacinda's out, Chris Hipkins is in. Chris Hipkins announces that we're not going to have time to put through legislation that reflects the changes in the working group. But if you vote for us again, we will put that through. National jumped in at that point and said, we're not going to undo that work. If we get in, we will bring some legislation in as well, but we might make some tweaks to what the working group recommended. You're completely right, Joe. When Brooke Van Velden spoke on employment law issues for the Auckland Chamber of Commerce a few weeks ago now, she essentially outlined that they're not actually going to adopt those working group changes and they're essentially going to start again. I think there is some joy amongst employers and payroll providers around that, because the actual calculation aspects of the proposed changes were arguably going to be the same, if not worse, than what we're currently dealing with. It will be really interesting what they do with these issues of people being entitled to sick leave, bereavement leave from day one of employment. I think it is highly unlikely that the ACT Party will support that. So we've kind of gone back 6.5, 7 years in time. We're starting again. The only thing we all still agree on is that the Holidays Act is a mess, and watch this space. But Joe, as you said, Christopher Luxon has said that it is a priority for them to tidy this up. So hopefully it's a little bit quicker than the 6 years we've currently been working with.
So if I could just get you to heed your own advice there on the gesticulation a little bit.
Did Andrew text you to say that? Thank you.
Yeah, at the risk of dislocation for myself. I think the one thing though with that reform, some of it was kind of no-brainer stuff, right? You have if someone comes back from parental leave, then they're penalised in a certain respect because their holidays are paid out based on their previous 52 weeks average of that, and that's always going to be artificially low. So I think some of those things possibly should have been looked at as just passing through in isolation with urgency. But I suspect you're right that it's going to take some time before we see any change at all now.
Great.
Another one that Brooke Van Velden covered in that speech, which I was a little bit surprised about personally, and she describes as one of the areas she's most excited about, was reform of health and safety law. And she was saying basically Health and Safety at Work Act is about 10 years old now. Let's see if it's fit for purpose. It was also based on consultation with businesses and schools as well, saying that they just don't understand it. They're not sure how to comply. It doesn't fit with, say, juggling several children in a classroom, and some businesses are just whacking up posters trying to comply. Angie, do you think it's time for an overhaul there?
That's an interesting question, Joe. If you go back to the history of how this piece of legislation came into play, we borrowed heavily from the Australian occupational health and safety law. And in fact, if you go to our Act, you'll see that there are references to the Australian law rather than our previous Act. I think it's as much about education under the Act, but also application of the Act. one of the problems we have in New Zealand is that we don't have the resources in WorkSafe to be able to apply this Act in the way perhaps it's meant to. So do we go and revisit the Act and amend it? There's probably some amendments needed to clarify some aspects with some probably unintended consequences. But otherwise, I think it's more about resources for WorkSafe to be able to apply the Act appropriately. Because the Act was brought into place to try and reduce serious harm instances and fatalities down by something like 25% over a short period of time, and I'm not sure they're achieving that. So for me, it's about resources and education, less so about amendments, apart from some unintended consequences.
Okay, that's interesting. I guess with amendments as well, because it's quite general in nature at the moment, but if you're to make it more specific, it's hard to do that in practice because obviously each business has its own unique workplace risk assessment. So it'd be difficult to do, I think.
Yeah, and one of the major tests in the Act is reasonably practicable, and it was previously all practical steps. We've gone to reasonably practicable. So arguably, it's a bit more vague, and it's a bit wider, but it seems to be working. If you look at the test of what's reasonably practicable, you can apply the elements of that test, I think, effectively to most of the provisions in the Act.
Okay, and another one, just covering off for completeness mainly, is the adventure regulations we've got now, and I think those are important for that. This obviously came out of the Whakaari litigation, and looking again at WorkSafe's role actually, because they were found wanting in several respects, and probably a lot of that comes down to those resources you're talking about, Andrew. But this is for anyone operating an adventure activity now needs to pay particular attention to natural hazards and needs to go through a process under the new regs, so something to be aware of as well there.
Yeah.
Moving on to independent contractors, and this is one that was in ACT's policies in the election, and jumped out at me, and I was surprised at it. Was essentially saying that we want the contract between the parties to be determinative of whether they're an employee or an independent contractor. And obviously that runs extremely counter to current law, and the courts are at pains to go through particular tests to identify whether someone is an employee and an independent contractor. So I was surprised to see Brooke Van Velden mention this as well in her speech about changes they're looking at. Andy, any thoughts on this one from you?
Yeah, I think, Joseph, the problem with that's always going to be, and I think there's some observations in recent case law, and I'm thinking of the Uber decision principally. There's always going to be, and I think it's quite far-reaching as well. There is a power imbalance, and if you give an organisation an option to go an easy road, and that's going to be lawful to do, then they are going to attempt that. And not everybody has the power to bargain sufficiently that they can say no to agreement. And just we've had this really economy lately, which I think has kind of illustrated the point. I do quite a bit of work with the tech and games industry, and there was a period where it was very, very hard to find staff, and these are gig economy employers, for lack of a better word. And what actually happened was, because they couldn't get enough people, that really gave people in those industries the power to say no to these gig economy contractor arrangements, and they were saying, hey, actually we want an employment agreement. But I had a few clients that actually had to come to me and say, we need to update our employment agreement, we need good people, and they're saying to us they're not contractors. And then of course the worm, and there were quite a lot of layoffs in tech. So I overestimated the effects of COVID and thought that we would be video conferences forever and nobody would ever meet face to face again, and everybody would do everything online. And they all took on too many people, and that caused the scarcity. And then they subsequently laid them off. And what I saw with my clients is that they were able to lay down the employment agreements and go back to the contractor arrangements. So it's a very real thing. And I think that organisations, particularly in that startup zone, and they're medium-sized, they're small, they have quite a lot of apprehension about the Employment Relations Act and the responsibilities that go with it. And if they have sufficient bargaining power to do it, they're always going to push something that's a bit easier, and that's significantly that's out there in a big way in my experience. I know that's anecdotal, but that's my view on it. So I think if intention became the touchstone, you would actually see contractor arrangements become much more prevalent, and where they're going to be prevalent is where people don't have that power to say no. And I think if you look at the Uber decision, and I think it's a well-written decision, and it's a very interesting decision, but generally Uber drivers they don't have a lot of power in the situation, and if anybody cares to, the decision's really interesting because it highlights the way that Uber actually, despite people being able to clock on whenever they want, the control that Uber actually exerts over them through the mechanics of the app is actually pretty extreme. And I think, Joe, for me, making intention the touchstone, I think that's going to have some bad consequences for ordinary people in their lives. So I'd have to say it's not something that I would like to see. And no bias, you know, it might it might do us out of a bit of work if people no longer have to comply with the Employment Relations Act. But no bias here, and I'll stop.
No, I think I think it's an extraordinary concept because you're going to be able to circumvent employment law essentially on pretty widespread scale. So I think it's incredible. Do you think it would make it through the select committee stage? Is it something that's going to be shut down?
I think, I mean, you need quite, if it's going to get to a second reading and that kind of thing, it's going to need broader support than that. So Lux International would have to get in behind it, and I haven't seen any signalling in that. I think National is actually quite a centric party. Its policies are very centric, and I just don't know if the appetite to upheave the Employment Relations Act by making intention the touchstone in contractor arrangements. I just don't think the will is there. And I think Brooke herself and some of her comments was sort of alluding that her policy advisors might water her down a little bit. So I think that she might be carving out an escape route on that front anyway, Joseph.
Makes sense. Obviously on that independent contractor front, and Andy, you mentioned the Uber case. So great. So it's a great read. I think it's really well written. We've got the appeal, which I believe the Court of Appeal heard a couple of weeks ago, I think. Anyone care to offer a prediction on that one?
As much as I like cheap rides, we might be in trouble.
Yeah, I'm on the same boat. Fee, what do you think?
Yeah, look, I agree with Andy. I think if Uber do lose this at the Court of Appeal stage, I think they've got no other option but to try and appeal this to the Supreme Court, because this has huge ramifications for them. But I think either way, whatever the outcome is, there's going to have to be some legislative tidy up.
Yeah, I agree. I mean, the problem I think we have is that we have a Court of Appeal that is really considering this new type of work in the gig economy, and I hope they have some either expert evidence in that area or certainly some understanding, because I believe this case, irrespective of how well it's written, should be in favour of Uber, but I suspect it may not.
It's quite difficult to see in the Court of Appeals looking at it to see where the employment court could have gone wrong, because it's quite a general test in the legislation of how do you assess whether someone's an employee or an independent contractor. You've got to look at the real nature of the relationship, which is incredibly vague. So I think it's going to be a tough one for the Court of Appeal to say the employment court got that wrong. So, another one interesting that's popped up, and we've written a few articles on this one, is the Remuneration Disclosure Bill, which is essentially saying that employees should be free to talk to each other about what their income is. And I suppose this is looking at things like probably gender pay equity is a big part of that, and just a bit more transparency. What do you think about this one, Fee?
I really want to have a good rant about this, and it's important that you hear me during that rant. Guys, can you hear me okay, or is it a bit all over the shop?
There's a little bit of an echo coming through.
Okay, you can hear me. Okay, so my view about this is, growing up, my dad always told me, you never talk about politics, we're breaking that rule now, religion, we're not going to go there in this webinar, and how much you earn. And I think that has always been the philosophy in New Zealand. But I think where Kiwis are starting to land now is it's actually to their advantage to talk amongst themselves to work out what their peer next to them is earning. Otherwise, they might be being ripped off. So we are starting to see culture change there. What I don't understand about this legislation is what is the problem we're trying to fix. I have never in my career, and guys, I'd love you to jump in if you've had something different, but never in my career have I had an employee come to me and say, Fiona, I'm in trouble with my boss because I talked about how much I earned. On the flip side, employers have called me before and said, look, Joseph and Andy had a conversation about what they earn. We want to discipline them, can we? And my advice has always been, no, you can't legally do that. If they want to talk about what they earn, that's up to them. So I don't know if I've completely missed the point on this, but I don't understand what the problem is that we're trying to fix. If we are trying to encourage employees to have this dialogue, I don't think this mechanism is right. I think that's a whole different piece of work, but I don't get the point of this, but one of you guys might be able to provide some assistance there.
Any different views, Andy, Andrew?
No, nothing from me. It's interesting because when you're in collective bargaining, often there's a clause in the collective agreement saying everything in here is confidential, don't talk about it. But sure as hell, next time you come up against the union, they'll be talking about collective rates from other collective agreements. So hopefully Fee's view on the fact there's no union people on this webinar is correct, but that's my experience. So, but look, it's your personal information. How much you get paid is personal to you. If you disclose it, I don't see a problem with that. So again, I think there are bigger and badder things to deal with. This doesn't seem to be one of them for me.
Okay. Andy, I think you're on. You might be on mute there, Andy.
I am. I'm just trying to cut back on. I don't have a lot to add other than to observe that what's left if you can't talk about religion, politics, or what you earn, Fee?
No comment.
Okay, well, good to get the party line on that one. The next, we're going to move on now to case law, and this has been a pretty interesting area recently, particularly when it comes to awards of compensation. And we've seen a couple of cases, one of which was this case called Cronin Lamper, and this was a couple of counsellors at Melville High School. They were there for about 15 years. Over that time, there were 32 deaths in the community, including student suicides, fatal crashes, terminal illnesses, and murder even. And those two individuals were for assisting students and staff and the wider community as well in managing the crisis response. They said they were overworked and under-supported, weren't given under-supported in respect of they're clearly dealing with very, very difficult issues, and the employer is not coming through and assisting them with that. They were eventually diagnosed with PTSD, and the court said that the school knew or ought to have known about the impact this work was having on them, and that it breached its health and safety obligations. So they got close to a combined $1.8 million. That was including damages for non-economic loss, which combined to over 200K, significant lost income and interest, lost superannuation, capital loss for sale of rental property, rental loss, and medical expenses, which is extraordinary. Any takeaways from this, Andrew?
There we go.
You're
I'm
on mute as
muted.
well.
Look, I'm muted now.
You're
There we
good.
go. Good. Look, extraordinary case. Yeah, the amounts awarded in that decision were quite eye-watering. And in some respects, it's about time that those who are responsible for significant harm in the workplace are fined appropriately. But in other respects, it was pretty damn high. There was a really interesting case in Australia involving the Court Services Victoria. Now, this was a case under their related health and safety legislation. But in that case, their Court Services Victoria, they provided services to the magistrate court. So it was actually within the judicial system. It had a very bad workplace. It was a toxic workplace, which involved people seeing traumatic material, exactly what you've talked about here, high workloads, poor workplace relationships, etc. And what happened in that case is they were fined 380,000 Australian dollars. So a very high fine, and of course it was a criminal offence. And what the court said there was that workplace-related mental illness is something that comes under health and safety legislation and is something that's on the increase in Australia. So what we're starting to see is more prosecutions in Australia for this sort of thing. And I know in France there's been a similar situation involving their telecom provider where there was significant harm caused to people, including numerous suicides. They linked back to the workplace, and there were criminal offences. So what I think we'll find in New Zealand is not just the civil cases where we get these very high awards from the employment court and perhaps the authority, but I suspect WorkSafe will be looking at this for a prosecution, and they're going to look at the right case to prosecute first up. And as I say, it's a criminal prosecution with maximum fines up to $3 million plus imprisonable sentences. It could become a really significant issue, I think, from an employer's perspective. The simple message is, to try and prevent workplace-related mental illness, you've got to have the right processes in place, the right culture in place. And if you don't have that, you put yourself at risk.
I think if you don't think about your employment law risk and your health and safety risk is entirely separate. I think it's always important to know that there's an implied term in all employment agreements that you've got to take those reasonably practical steps, and that can come back to bite you. But there's certainly the mental health side and things like PTSD, as we were seeing these awards. There's another case, wasn't there, Fee? This one on the authority, I think.
Yeah, and I guess once again, this is a little bit of an outlier when it comes to the awards that were handed out. And I guess to provide some context on that, when parties come to us and say, look, what's the worst case scenario if we all end up in the authority? When I talk about averages, I say that an individual might receive around 13 weeks lost wages. They might receive hurt and humiliation compensation. The average at the moment seems to be around 20-25, and then they receive quite a minimal contribution to their legal fees. I know, Joe, we worked on a matter a couple of years ago now involving the education sector. That was a bit of an outlier. The individual was awarded 3 years lost wages and from memory around $40,000 compensation. This most recent case is a bit of an outlier as well. So this is Parker and Magnum Hire. And their evidence was well beyond the employee was hurt and humiliated by what had happened. There was talk of the individual suffering from depression, anxiety, symptoms very close to PTSD because of the way that they were treated by their employer. Now, that individual received $105,000 compensation for hurt and humiliation. Essentially, that was made up of $50K for a constructive dismissal claim, $50K in relation to the disadvantage around the bullying. There was also an issue around a suspension where the employee was awarded $5,000. So once again, I don't think panic. I think that is a bit of an outlier. But when individuals are able to show that they have suffered beyond your standard hurt and humiliation threshold, and we're talking about things like depression, anxiety, PTSD, I think those awards are going to be up there in my view.
Yeah, just add to that, Fee. I mean, it's really interesting that the authority and the courts now are increasing the humiliation levels. Previously, you would find higher levels with a breach of contract claim. So you would argue that under Section 161 of the Act, the employers breached the employment agreement by not providing for a safe work environment. And I had a matter in the employment court where we looked at the higher end of those levels. You know, the $60,000 to $75,000 general damages, which is equivalent to humiliation compensation, was the higher end. Now we're starting to see 105 in the authority. I suspect that, you know, for people bringing breach of contract claims for failure to provide a safe work environment, you might start seeing 100 plus there as well, in the right case. So it is, I think it's, as you say, not a time to panic, but truly looking at the way that Australians are pushing through prosecutions for health and safety, looking at the way New Zealand courts are looking at really compensating people where there's harm caused in the workplace. It is time for a lot of employers to reassess, have they got the right culture? Is there that bullying manager in the workplace they've got to deal with? And think about the consequences.
Yeah, good point. I think another part is you see a lot of cases going on appeal to the employment court analysing the authority's assessment of what's a reasonable compensation sum and saying you've got to do it within these bands, and they're frequently increasing the amounts the authority awarded, and presumably the authority is looking at that, and it flows on. I think it is definitely on the up. Another case I wanted to cover, which is it's totally off track from that health and safety sphere, but a really interesting one was a case of Evolution Traffic Management, and this was for the solicitation of employees. So what we often see, or should we see kind of every week really, is cases about non-solicitation of clients and restraints of trade. But this was where someone left a business and recruited his former colleagues and set up, took them over to a new business. So he was involved at his employer in recruiting and managing staff. He had a 3-month restraint preventing him from encouraging staff to leave or to go to a competitor. He formed close and personal relationships with those staff, and then he went across to a competitor and took a bunch of them with him. And the company sought a declaration of breach and penalties against him and succeeded in doing that. And so there are a few bases for that, one of which was breach of fidelity, because he did some of this while he was employed. The other part was breach of the post-employment restraints. And the other part was aiding and abetting one of the employee's own restraints. They succeeded on all of those. And they ended up getting an order for, I think it's about $25,000 in penalties. I thought it was an interesting one. Andy, any comments on that one? Any lessons from that?
Yeah, I can't help but think they might have missed an opportunity there, Joe, because I think traditionally if someone breaches, well, certainly if they breached an ordinary contract and they suffered a loss that naturally flowed from the breach, you would go after that loss. And I understand in this case what happened was that they actually lost relatively significant pieces of work, so they could have pursued the profit on that piece of work rather than penalties. And penalties, I mean, they did quite well on penalties because penalties are a bit of a wild card, and that there's always the question of whether the authority is going to see them as distinct incidences or roll them all together in one and maybe give you $5,000 penalty on it, in which case your case isn't worth running if that's the way that they view it. So although they did all right on penalties, it feels to me they probably could have done a lot better with a contractual breach claim. I mean, the only reason I can think of why they might not have done that is maybe that loss is a little bit hard to ascertain. There might be something nuanced that I'm not seeing, but certainly it looks like they could have gone to the top and didn't.
Yeah, interesting point, because sorry.
No, so I was just going to say, I agree with Andy there. 25K is hardly going to be enough. You know, if Joseph, after this webinar, you decide to set up a rival law firm, you weren't supposed to smile and nod then. You know, a 25k slap on the hand is nothing, right? So I agree with you, Andy. There might be stuff behind it as to why they ran it that way, but it doesn't seem a lot, does it?
No, in fact, it might be economic to poach all the staff and just take the 25 on the chin as part of doing business. So it hardly dissuades it, really, does it?
Okay, now you're giving them ideas. Stop talking now, Andy.
Interesting to say that.
Look, I've been involved in some cases like this, and it's called a springboard action, where you effectively go and take a whole lot of clients, or sorry, employees away from your employer, and the remedies can be massive. You know, not just recruitment fees to replace them or temporary employees at a higher rate, but the potential damages. So, yeah, likewise, I'm a bit surprised at the low level of this case. Maybe it was the way it was argued.
Yeah, look, I agree. And in terms of the loss, I think the authority actually commented that it had caused them to default on various contracts, so that should have been easily identifiable from an evidential perspective. So really curious. It also they're lucky because the penalties went entirely to them rather than the Crown, but the default position obviously is that can go entirely to the Crown or 50-50, another proportion there. So they got quite lucky there. But yeah, it's an interesting, good idea there. You're right, Fee, because in that case, Andy, actually the employee didn't engage at all with the authority, and you always run a risk when you do that, but then only be copped with 25k in penalties. It probably was economic from there. So food for thought. So those are the cases I wanted to cover. I'm not sure where we are in terms of questions. Andy, are you getting any through there? Or?
I do have a field, but I think we might be having a few little technical issues. Sorry, viewers at home, but I've got nothing in my field. But if there are questions that we haven't answered, we have talented law clerks and junior staff that will whip around and compile the answers. So don't feel like we're not going to answer your questions if you want to fire some at us.
So, and thanks very much for joining us. Obviously some pretty interesting areas there in terms of what's next for the government. So we'll be keeping a close eye on that, and obviously we produce articles and updates on that. So keep an eye on those too. Thank you very much, and thanks for Andy and Andrew.
Great. Thanks, Joe.
Thanks, Joe.
Thanks, guys.